there are very substantive issues of law which are involved. Obviously, all this is without prejudice to that. This, at the best, what is being suggested is administrative tweaking where necessary in a committee based on suggestions. Legal tweaking is another system. The laws are involved in many places. So what we'll do is we'll confer. Without prejudice, we can certainly give. But personally, I don't think that your lordship will have any major solution. Having seen the gamut of problems and the level at which conceptually and jurisprudentially matter has been argued, I think it is better that your lordship spend so much time to go on to a decision. But we will certainly give this. This can be an addition. Anything tweaked administratively and helping is always a help.
Because I think, sorry, Dr. Singhvi, look at it as a one or none. Because although he's saying administrative, there are substantive issues here. When you're looking at insurance, your housing, etc., these are as substantial in terms of the benefits that people can expect. That is actually the practical way out. What are the barriers which you're facing? That those barriers you should give it. If there is a frank discussion out of that, although this is being termed as administrative, this will have to translate into some changes in the regulations, maybe even law. So to what extent they are willing, to what extent...
Certainly, but the word administrative I said was that many of them will require substantive changes to law, which I don't think is what my learned friend is saying. What he's suggesting is that a circular may be changed. Office order may be changed. I may be wrong.
No, I'm just the intention.
Without thinking of what do I learn.
Whichever mode, method or manner in which that problem, if permissible, can be addressed, that's my lord. There is no existing rule which...
Let's come down to some example. I think Dr. Guruswamy made that chart containing or even you had presented a chart of the seven items. Some of those don't require substantive.
So therefore,
now, sometimes beginnings are small.
No, certainly.
Those beginnings could be very substantial in that sense.
I bow down. Beginnings are small is absolutely opposite, but whatever little is given by administrative tweaking, certainly it would be welcome. I'm only saying, that this should be seen as a constructive effort towards a convergence. It may not, be a substitute for the larger. That's all that I'm saying.
But Dr. Singhvi,
yes.
One step at a time, while the matter is on.
Yes. Immediately, I started by saying that. We will
do it. Maybe if there is any statutory tweaking required, depending on the kind of needs that have been highlighted by.
Yes.
Be open to look.
What we are right now,
we will do,
aware of what we are dealing with. Suppose there, as my lord very rightly pointed out, that it might need change of law, and change of law might need, some wider issues of recognition of a particular relationship. Then, we will have to examine whether that can be done.
Also, Dr. Singhvi, the way we are looking at it is that from the drift of the submissions which were made by the learned solicitor on the last occasion, it appears that the solicitor also accepts that, of course, people do have a right to cohabit, and the right to cohabit itself is something which is now an accepted social reality, at least. Based on that, there may be certain incidents of that cohabitation. For instance, in relation to your right to reside together. Second, bank accounts, insurance policies. These are practical issues which can be resolved by the government. From your perspective also, this is a step forward.
Absolutely.
See, for example,
therefore said you don't have to go for all or nothing approach.
For example, two persons, two old men are staying together. They are not necessarily in any gay relationship. For companionship, for looking after each other, etc.
That analogy misses the point. It does not take an assertion of rights for two adults who are self-sufficient to live together. That is an exercise of free will. Rights is a proactive, positive enactment that the law recognizes. There is a distinction here. So an old man being taken care of by a caregiver misses the point.
No, but that's not caregiver. Two people, three people staying together, they want to share their bank accounts, their insurance.
We are talking specifically of same-sex relationship.
A caregiver taking care of a person under his care, or a relationship where you're claiming these rights.
practical effect would be that the
You're
caregiver,
cohabiting.
let's say the person who is the one who is being cared, he is neglected by his sons, he is neglected by his children or other relatives. He does not want to give it to them. Now, short of creating a will, in case he dies intestate, if he has a nomination, he cannot nominate this. See, today
Be a part of, say, medical insurance. He wants to be a part of medical insurance.
But may I just say this? For something as simple as pension, provident fund, gratuity, benefits, that accrues only in a marriage. It does not accrue to the caregiver. What accrues to the caregiver, even in other systems?
That's the reason why one is putting forward this idea.
Yes, my lord.
And that accrues in a marriage because of the nature of our rules.
Correct.
If you have to, therefore, that's something exactly which the government has to consider. And that's why we thought.
Suppose hypothetically, I do not know, my lord, what will be the implication. My lord, suppose the government says that nomination in case of provident fund would be a family member or anyone else which the retiring person chooses to. No, then you don't need to go into anything else, my lord. The problem is solved.
Let us be clear. Just
Sometimes solutions are, my lord, simpler than the problems.
To be clear, when you got Justice Paul is saying.
Once again, Justice Paul wants to say something.
Dr. Singhvi, please notice, as my brother colleague said, this is without prejudice to everybody's rights and contention. One. Number two, even if the court was to, suppose you were to succeed to a limited extent and the court was inclined to give you a status of a marriage or inclined to give you a status of some other status, let us say not marriage, but some other status, there will be many changes required in administrative proceedings as also legislative aspects. Therefore, if there is a consensus, at least whatever be the status recognized, after all, they are not denying that this is an incidence of society which is happening. They are reluctant to give it a status of marriage. But they are not, I believe from what Solicitor says, reluctant to sort out the problems arising from a gay companionship without labeling it as marriage to the extent possible. Now,
may I respond just 1 second?
It's not gay, but there are several combinations I don't wish to go into.
Mr. Solicitor, let the
It becomes unmanageable, my lord, to fathom.
let me
Multiple combinations, my lord, which can arise.
let
me complete, Dr. Singhvi. Let me complete. Yes. Therefore, what is the suggestion from the bench is that the nitty-gritties of what may in any case be required to be done in either situations, some endeavor or step is taken in that direction. I think that's what Justice Bhatt and the Chief Justice put. So I think let us, without prejudice to anything else,
absolutely
not sit with pre-notions or prejudiced notions on either side as to what can be started.
I start with that.
To both the contentions.
Solicitor, 1 minute, please. Whereas I start with that, give me just 2 minutes. Your Lordship may take it. I started with that. And I'll do better, Wallace. I'll try and make a chart which is actually 3 categories.
Right.
And a 4th is, Wallace, conceptual. Give me just 1 minute. One category clearly, possibly solvable immediately is the so-called administrative tweaking, which is followed from my Lord Justice Bhatt, Justice Call just now. Surely what you can get by easy tweaking, there is no question of looking a gift horse in the mouth for no reason at all, just because we are on some principle. Of course, it should be cooperating. Of course, we'll give that. A second category may be something more than that. A third category may be substantive, bigger changes. I'll try and identify them separately. But above all these 3, so the first category, Lordship will take it, people will meet up, people will make a list, people will share it with the solicitor. We have no problem, we have no ego about it. The 4th idea is important for Lordships, and only your Lordships can decide it. That is the real, the symbolic, the actual meaning of marriage. That nobody can decide except this court, this way or that way. No committee, no circular, nothing can. Now that's the juristic question. 1 second, Mr. Solicitor, 1 second. That's the juristic question. Now, therefore, we are, as Justice Call said, we are happy to divide it, and what might be called low-hanging fruit.
Yeah.
Benefits everybody, everybody eats that fruit. Of course, we'll cooperate. The other fruit, will have to depend on some kind of an order. And we'll make that categorization to the best of our ability.
Equally, Dr. Singhvi, when we go into the conceptual domain,
yes,
we cannot be oblivious of the fact that to the extent to which the conceptual domain requires legislative changes, that part clearly lies outside the
Part of the
remit of the
dialectics.
court.
That will be part of the dialectics.
Then the question which the court will have to face is to what extent does the court go in formulating conceptual doctrine?
Yes.
Absolutely.
Because ultimately whatever doctrine the court formulates has to be relevant on the ground. All right? Therefore, there may be three levels really. There may be certain areas which are governed by pure administrative changes.
That's what
which can easily be done by them. Second, changes which they accept as a matter of principle, which may require changes in some form of subordinate regulation. Which again is a matter for the government. They don't have to go to parliament for that. Which is again much easier to achieve than say a parliamentary change in legislation. The third is your wider.
Exactly. That's
your widest case, your fundamental point is that, well, there is a right to marry, one, with reference to constitutional precepts, even for same-sex couples. Second, that you can found that or source it in the Special Marriage Act.
It's not a hollow right, it's not just a shell.
That is what you have all argued. That is what you have all argued. That's something which we will have to ultimately decide, subject, and therefore that's what their argument is.
That's all that I'm saying.
That this is essentially a legislative arena, don't step into this.
Dr. Singhvi, yes.
Therefore, we are saying that, well, we will of course have to decide it. We are going to decide this entire issue as a matter of concept. But to the extent to which the government takes a first step forward, there would be a substantial benefit, a substantial advancement in the recognition of the cohabitational relationship of same-sex couples in the country today, which would be a substantial advance beyond what we have today.
Yes. I certainly have no such.
That's exactly the point. I would put it like this, somewhat like this, a bit differently, which is that Dr. Guruswamy and I think Mr. Kripal, all of you in different ways said that, this could be a part of a series.
Part of a?
Part of the series, whatever you want. Look at it from the reverse. If this results in a gain, maybe not as substantial as you visualized, right? That's one of the building blocks for your future, No, do you want a ruling then? That too is something you may have to consider. Given that you're now not really fighting a battle only for these petitioners, but there's a larger group of people who may not be covered by this dialectic of Special Marriage Act. So then, is it advisable or prudent if you're going to get this to continue with that larger push?
We'll build that into our argument.
Have to take that call.
We'll reflect on that and build that into our argument. We fully understand what my lord is saying. Fully understand.
Can I say one thing?
Only one request I would make.
People who are not in that part of the dialectic. We've all gone and spoken in seminars, and there are people who believe in the absence of heteronormative institution of marriage. And when one goes out and meets 99% of the people who come up to you, they all say only one thing, that they want to get married.
Yes.
But the consensus within the community, no matter how many people may say that it is a concept that they otherwise reject, is that they wish to have marriage.
Yes.
Because this gives meaning, purpose, identity to the people who are seeking to get married. Because and my learned friend will agree with me. So it's not correct to say that there will be people who will be out of the bound of marriage, who don't want marriage, but they are happy with something else. I, Millet, personally, and I'm sure Ms. Guruswamy and Ms. Grover as well, in all the multiple meetings we've had, we heard some academic discussions of people who say, no, it's a heteronormative institution, it's not necessary. The vast majority of the young people I have spoken have all said, we want to get married. The parents of those young people have said, we want to get married. Because we say we want to get married. Why should we be second-class citizens? Because there was a time we were criminals, then we became third-class citizens. Now they're saying be second-class citizens, then be content. That is not what the Constitution promises.
Yes. So that's the third category. But I am not belittling your lordship's first or possibly second category. Please don't misunderstand that. All of us here, but we are all imploring your lordships to recognize a third category incapable of partial, minimal resolution by the Solicitor General. Incapable. But the first or the second, yes, we'll fully cooperate.
And one exercise we also undertake.
And we'll keep that point in mind, that whether we can give up something, not give up that part, I understand.
And ultimately...
No, in the sense, that it can be tailored.
You've given up anything.
No, for us, tailored.
My lord,
can I suggest also, we amongst ourselves, all the petitioners, are sitting down and we are trying to make some kind of a draft of what is it that we can hope to achieve. So there's a consensus in ourselves. We understand we can't get everything. Because we will put forward some idea of what is it that we hope that this court can give
That's
us.
exactly why we thought that some
Well,
sort of
that is
meeting of
that's our
some
concept.
exchange of ideas between all of you would be helpful.
Consensus is amongst us already that at least Section 4 recognition of marriage has to be given. What rights follow from that, when, how, those modalities.
Yes.
So that is legislative. My lord, therefore, my lord, I would request.
May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, I make it a point to speak in small towns India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where there is marriage equality.
On the marriage.
Dr. Guruswamy, there's a problem with this line of argument.
No.
I'll tell you why. We understand the feelings out of which this argument comes. But at the constitutional problem, at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by either popular morality or a segmental morality. We decide what the Constitution says.
But this is...
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us about what the country feels. Let's not get into it at all.
My Lord, this...
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You're also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in Section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure, by acting as a facilitator, that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize a right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation, or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this dialogue.
See, if you've seen the history, and I think this side, you're all acutely aware of the history, you know better. You've seen the ups and downs of that for the last half century, and where it went to, what kind of legislation came, not positive, mostly negative, and how finally you got the judgment that the US Supreme Court gave. Now, you are circumventing all that. Of course, there is a lot of, let's say, feeling in this, a lot of felt, experiences in those. Nobody is discounting that. But if you do gain something out of this, that's a big positive. Because, I mean, there are so many processes outside of what we can speak in this country and in society generally, that these gains are also not to be belittled. Now, if you're likely to get it, I mean, just sit back and think what you're gaining.
Yes.
And then if you are still pushing ahead and you want that declaration, we will have to examine it. And even this closure or whatever, if this happens, I mean, this is completely, please let me complete. There is no closure. What I'm saying is, if there is some quietus to this at this stage, don't see this as the end of the battle, or whatever your movement is. Because ultimately, whatever your movement for equal recognition of equality of that would always remain. And even if these, whatever you get, the positive part of it, even if you don't accept this or partly accept this, now that too will not be the end for whatever you're going to do. One is speaking generally, not in any manner prejudging it.
My lords, in Obergefell and in America, the experience was that after Obergefell, when the Supreme Court gave its broad declaration, broad and firm declaration, the counsel for the parties then sat with the government, with the administration, and went through each law. And each department sat with them and they went through each law. I'm told it's 710 laws or something, and then sat down line by line and sorted out post the declaration in Obergefell.
But that was a different kind of, let's say, working out, because they had to work out what was unconstitutional. Oh, we are literally putting the alphabet together.
Yes.
That much harder.
But my lord,
And even Malhotra,
And not
there are good
not only
reasons in
mere
the
laws,
minority
there were
views also.
constitutions. There were constitutions which had to be invalidated.
but my lords, the only thing I will say
In
is that
fact,
we as
in Malhotra,
jurisdiction,
this judgment my learned friend is relying upon,
we as a
there were restrictive statutes which came before the Supreme Court.
but we as
Some states had
Now,
jurisdiction.
Mr. Solicitor, coming
My
back
lord-
to your submission, let's get on with that in
that's
another
right.
10 minutes. We'll put
Yeah,
we'll put the
Yes,
next
yes,
batsman
we'll
in,
do
and
that.
I believe the
Yeah,
next
Malhotra,
batsman will be learned batsman.
only one request Malhotra, to the other side. While giving the suggestions, Malhotra, I would request them not to give jurisprudential ideas, etc.
No, not at all.
Only-
That's for us.
Of course not.
Only
Again, a third
factual
category.
problems
Obviously.
which can be addressed by the
Jurisprudential is on this side,
administrative.
but not that side.
There's no delegation of the judicial power of the court.
Yeah, yes. There can never be, Malhotra, there can never be. A lot of
Singhvi.
shoulders are the strongest, Malhotra. But it may not happen, Malhotra, that the committee doesn't understand what the issue is. Let it be as simple as possible. That's all.
Little legal training.
Dr.
Make
Mr.
it-
Solicitor,
make it very
we've
specific.
now heard your submissions. We are now almost at the wrap-up point of your submissions. The jurisprudence which we have considered, and your line of submissions, I think there is an area which, even according to your submissions, then that the court can go into, namely to recognize that same-sex couples would have a right to cohabit together, and cohabit together in a normal, peaceable environment in our country without any form of discrimination, either societal or otherwise. Step two, that the government would, as we now see from your very fair suggestion that the Cabinet Secretary, no less than the Cabinet Secretary would be going to it, would be recognizing the incidence of that cohabitational relationship. So we can certainly build upon our jurisprudence as going to that level. Question now is, and we don't want to stop them, whether we make that extra mile, which is what they have argued. And we have also argued that, look, this part would be a legislative exercise, don't step into that. So now what else remains? You can now wrap
Can I
up in 5
conclude
minutes
in
so that we can
15
have
minutes?
someone else.
I'll wrap up in 15 minutes, Malhotra. Malhotra, I have filed one note. I'm not going to read it, Malhotra. At the outset, I may put that caveat, Malhotra. But there are only 3 points, Malhotra, which I am making. Malhotra, I'll just give broad propositions and I'll not read it, Malhotra, what is not relevant. Malhotra, my first point, that recognition of marriage is not a fundamental.
There's a note one.
I'm so sorry.
नहीं,
Malhotra.
उसके नीचे है.
Note 3, Malhotra.
Notes by Mr. Mehta.
उसके बाद नीचे है थोड़ा सा.
Yes, so that's this.
No,
So
last time.
Yeah, this was cited last.
the title is Closing Points.
Closing points.
And my lords, my lord, I am obeying the continuing mandamus, my lord. I am
This one.
using the iPad, my lord.
Oh, that's good.
So a weak student, my lord, in at least schools I studied, used to get 5 extra marks for good handwriting. But I need 5 extra marks, my lord, for using this one on the lighter side. But my first proposition is right to get a particular social relationship recognized as a marriage is not a fundamental right, my lords.
Let's read it quickly. Let's read the note.
Yes, but I'll just quickly, my lord, go through. It is submitted that over and above marriage, there are a whole host of human relationships which exist in society, which may in some cases be even more valuable than marriage. The statutory law in any country in the world does not regulate all human relationships. The said relationship may be extremely important from the perspective of life and liberty and the dignity attached to it, and may further even have a more profound impact on the life of a person. However, sans a legitimate state interest, legislatures across the world have left a whole host of human relationships completely outside the legislative purview, denying any legal recognition to the same. It is submitted that the presumption, therefore, cannot be that the state is obliged to recognize all human relationships. Rather, the presumption has to be that the state has no business to recognize any personal relationships unless the state has a legitimate state interest in regulating the same. Even for heterosexual couples, it's their intimate relationship state had no business to regulate or recognize. Why the recognition came? Marriages used to take place even prior to 1956 because the court felt that we will have to regulate. You cannot be at free will marry at any stage, any time, at any age. You cannot marry as many times as you want. You cannot just say bye-bye and leave the relationship. You can part with your spouse only on certain grounds. When you are in a relationship, the children might be there. Who will take care of the children? So the question of custody needs regulation. Who will pay the alimony to whom? So alimony provisions came. So state should step in only when the state feels that it is in legitimate state interest to regulate a relationship, and therefore recognition is only a consequence of that decision. Hypothetically, para 3, it would be possible for a new religion, suppose new religion comes, to provide for a new form of marriage and new ceremonies for the same within the heterosexual fold. Marriage, Special Marriage Act or Hindu Marriage Act doesn't provide for any particular mode of marriage. Except in case of Hindu Marriage Act, it is that Saptapadi, etc. But suppose, someone just garlands each other in a temple. It's a valid marriage. Would a new law providing for a new mechanism be under an obligation, new religion providing for a new mechanism of marriage, be under an obligation that would be having a right that the legislature must accept that kind of a marriage as well? The answer would be no. Thereafter, second, I'll not read except the argument that marriage is a fundamental right was essentially based upon two judgments of your lordships. One was Shafin Jahan and another was Shakti Vahini. In none of the judgments your lordships were even remotely considering right of non-heterosexual couples to marry. In Shafin Jahan, please remember the facts. One lady, Hadia, a Hindu girl, converted into Islam, was seeking to marry a Muslim boy, and the family of the girl were objecting. Non-state actors were objecting. There your lordships, in a habeas corpus jurisdiction said that it's their right to marry. Because they are heterosexual couple, and your lordship specifically said that Muslim personal law allows the marriage. You have no business. The presumption was that it was a valid marriage recognized by the law, namely the personal law, Muslim personal law. Your lordships never remotely considered marriage as an abstract proposition to be declared a fundamental right, or marriage amongst non-heterosexual couples as a fundamental right. Your lordship.
Mr. Solicitor, conceptually, there's a little bit of difficulty about this argument. We understand the drift of the submission. Their argument is not that the state is duty-bound to recognize all relationships.
Yes.
You are saying that, look, there's a gamut of relationships in society. The state is not bound to recognize all relationships in society. Their contention is that by not recognizing same-sex relationships for the purpose of marriage, the state is acting in a discriminatory way. So the argument is really of the anti-discrimination principle. Not so much that the state is bound to recognize it or recognize all relationships in society. They say that marriage is a very vital social institution, step one, that same-sex couples are entitled to the same right to dignity as heterosexual couples, and not recognizing that relationship within the fold of regulation would be to deprive them of all the societal benefits which attach to marriage, and therefore it's discriminatory. So that's the line of...
To which, my lord, I don't wish to repeat, but, my lord, just to paraphrase once again, my lord, our respectful submission, my lord, is that this is a reasonable classification.
That's fair, and that you have made your point.
I have already made
now,
it.
Shakti Vahini, and this you have dealt with in point 5, right?
Yes.
You want to read that, or you have dealt
Lord,
with...
only highlighted part, my lord, your lordships may come to page 3, my lord.
Page 3, all right.
This is quotation from, my lord, Shafin Jahan.
Okay.
Where your lordships are very careful, my lord. The only highlighted part, underlined part. But the High Court unwarrantedly took exception to the same, forgetting that parental love or concern, my lord, daughter's parents, my lord, whose girl converted into Islam, concern cannot be allowed to fluster the right of choice of an adult in choosing a man to whom she gets married. That was, my lord, the broad conspectus that law permits a marriage between heterosexual couple. One is man, one is woman. The family has no business to interfere. Then, my lord, in Shakti Vahini was a different case.
That was a Khap Panchayat case.
Khap Panchayat, my lord, completely non-state actors, either by making regulations which they were not permitted to make, or by honor killing and other, my lord, extrajudicial unlawful means they were preventing. And, my lord, at page 4, if you're
point number 8 of your submission, where you have summarized what you're now saying.
Yes, my lord.
Therefore, it is submitted.
Yes, my lord. Therefore, it is submitted that said judgments were given in the context wherein state or non-state actors hindered the choice of a woman to marry the man she wished to. It is submitted that therefore there was an invasive positive act by the state or non-state actors in disallowing the exercise of choice in a heterosexual relationship despite marriage between them being recognized by law. It is submitted that said judgments are not, my lord. Then, my lord, kindly see, I'll not read it, my lord, but this Brown versus Board was cited by Mr. Vishwanathan. My lord, just to my lord, argue the separate but equal theory. My lord, this was a case similar to, my lord, what the situation was in India prior to independence with regard to some section of the society. They cannot sit in the same compartment. They cannot sit in the same place. There were different, my lord, provisions made, different classifications made for blacks versus white. So it was a racial discrimination. There was no intelligible differentia. And in that context, my lord, the Honorable Court said that it is not, my lord, your lordship's approach, my lord, para 11, I have, my lord, respectfully urged, my lord. Further, it is submitted that there cannot be a fundamental right, either under Article 14 or 15, to seek recognition to all forms of social relationships. It may be noted that the legislature does not seek to give recognition or any special status to all forms of human relationships. It is submitted that this Honorable Court ought to approach the present question not merely in the linear reductionist sense, as sought to be, my lord, made. This is, my lord, this is a classification made on the basis of nature of relationship. There is a reasonable nexus with the object. Object is the family, family as a unit, family having all incidents of the family, and continuation of the human race. So, my lord, I am not, my lord, repeating. I have already made my submissions, my lord. My lord, Citizenship Act and Foreigners Act, my lord, was thereafter not pressed. But, my lord, for completeness, my lord, at page 6, I have, my lord, put my submissions. I don't wish to repeat because they also very fairly did not press much upon it, my lords.
But then you've finally page 8 at the
page 8, my lord, your lordships, my lord, were pleased to require us to provide a comparative chart between, my lord,
that you have now
that, my lord, that is provided for. And, my lord, last submission, my lord, please, if your lordships can come to my note 2. Only, my lord, few good, my lord, illuminating judgments of the European courts, which would assist your lordships, my lord, I missed. And I felt, my lord, after arguing on the last occasion, that taking 10-15 minutes of your lordship's time, I must, my lord, advert to those judgments, my lord. My lord, if your lordships have my second note on fundamental rights, my lord. And this is the last submission, my lord. I will not trouble your lordships anything further. But some judgments, my lord, would really assist your lordship.
The European Convention and its gradual development, that part?
Yes. Lord, may I read 142? In Europe, and the European Court of Human Rights has its seat in so-and-so and is tasked with the compliance by the member states of the European Convention on the Protection of Human Rights and Fundamental Freedoms. The European Court in the manner provides an additional forum to litigant to enforce the rights under the ECHR against the against the nation state which is a member of the convention. The ECHR was entered into force in 1950 and is the main treaty which sets out the civil and political rights and freedoms of European states agree to ensure for people living within their jurisdiction. Lord, Article 8 is similar to Lord, Article 20, almost, Lord, not word by word, but peri materia. Everyone has the right to respect for his private and family life, his home, and his correspondence. There is a specific right to marry. Please see this, my lord. Article 12 on PDF page 77. Man and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Lord, two things. A, even European Convention recognizes a heterosexual marriage and it makes it subject to the national laws of each member state. Yes. Lord, therefore, the ECHR clearly recognizes right to marry under Article 12. Despite the same, European Court of Human Rights has still date refused to locate the claims of same-sex marriage under Article 12. The European Court of Human Rights had consistently denied all claims of same-sex marriages and still does not recognize marriage to be an enforceable right under the Convention. The European Court of Human Rights, after rejecting all claims for about 2 decades, has only recognized limited partnerships to be enforceable, that too in light of larger socio-political consensus in Europe. But this is not majoritarianism. There has to be a consensus on social issues. The said position is clear from a complete reading of the case law emerging from Europe. The European Court of Human Rights, for the first time, examined the issue of whether two persons who are of the same sex could claim to have the right to marry in the case of Schalk and Kopf versus Austria, and found that Article 12, the right to marry, of the convention did not impose an obligation on the respondent state to grant same-sex couples access to marriage. It was held as under, Lord, and I quote, the applicants were born in 62 and 60 respectively. They are a same-sex couple living in Vienna. Lord, kindly skip the, Lord, para 50, kindly come to para 58 directly. The court is not persuaded, Lord, it's on page 78, para 58. The court is not persuaded by the applicant's argument, although, as is noted in the Christian Goodwin cited above, Lord, some other previous judgment, the institution of marriage has undergone major social changes since the adoption of the convention. The court notes that there is no European consensus regarding same-sex marriage. At present, no more than 6 out of 47 convention states allow same-sex marriage. Then, my lord, para 60. Turning to the comparison between Article 12 of the Convention and Article 9 of the Charter, the court has already noted that the latter has deliberately dropped the reference to man and women. So, and so, my lord, I skip the commentary of the Charter, which became legally binding, my lord, that's for them, my lord, to para 62, 61 and 62. Regard being had to Article 9 of the Charter, therefore, the court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. Consequently, it cannot be said that Article 12 is inapplicable to the applicant's complaint. However, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. In that connection, the court observes that marriage has deep-rooted social and cultural connotations which may differ largely from one society to another. the court reiterates that it must not rush to substitute its own judgment in place of that of the national authorities who are best placed to assess and respond to the needs of the society. In conclusion, the court finds that Article 12 of the Convention does not impose an obligation on the respondent government to grant a same-sex couple, such as applicants, access to marriage. My lord, similar is the judgment at page 147. I will not read it, my lord, but same court, lord, similar reasoning.
Solicitor, we've seen it.
Your lordships have seen other judgments, but only one thing. Last, my lord, one page, para 148, my lord, that Oliari judgment which was relied upon. My lord, there the court, my lord, this was not read before your lordship, therefore it's my duty. The court records that in this country there is a larger consensus. Whether your lordships would adopt that, my lord, doctrine or not.
After that, there was a law after that.
Exactly, my lord. Therefore,
there was a law. But they did not say marriage. They said same, I think it's a civil...
Partnership. They said partnership. So, my lord, I am not reading, my lord, but I have collated all judgments on the point, my lord, and placed for your lordship's consideration. Lord, I'm immensely grateful, my lord. Lord, the learned attorney, my lord, would like to assist your lordship.